Good morning. If suit is filed, original petitions are filed, writ petition filed, any other original petitions before tribunal filed, and subsequently either the petitioner or the plaintiff or the defendant dies, what happens? So, the Order 22 of the Civil Procedure Code deals with the death, marriage and insolvency of parties. These all are consequential order affecting and discontinuing the proceedings because of this incapacity, death and so on, so on. About this, first I would like to discuss with you about the judgment when if the defendant dies. Pending disposal of the judgment, what happens? Whether execution petition can implead LR on behalf of the died defendant is a question which was discussed in the judgment. This is AR 2025 Gujarat 162, most important judgment. AR 2025 Gujarat 162. Pachim Gujarat Vijay Company Limited versus Hiraben Govindabai Vijay and others. The plaintiff filed suit for money, recovery of money, but pending disposal. The judgment was obtained by the plaintiff on 27th October 2005, but the defendant died 29th December 2004. So this is somewhat had happened. Thereafter, the plaintiff, with the help of the decree, filed the execution petition, and there the defendant, legal heir of defendant, filed an objection stating that Order 22 Rule 4 Subclass 4 is not enabling the degree holder to implead here unless and until he would have impleaded or exercised the Order 22 rules properly. So therefore, the execution court rejected and dismissed the execution petition, and this High Court, Gujarat, also rejected, confirmed the lower court order by following AR 2009 Supreme Court 2367. This judgment, Supreme Court judgment, also discuss upon Order 22 Rule 4 Subclass 4. That is one judgment you have to follow. Now I would like to say the Order 22 rule says no abatement by parties, the right to sue survives. Next, say one of several plaintiff dies, defendant dies, what to do, what not to do. Same sole plaintiff died, what happened? Or one of the plaintiff died, what happened? What to do, what not to do. Same with the defendant. Then when there is no legal representative, then you have to implead administrative general if there is a estate left by the defendant, the judgment debtor, and without legal act. So the determination of question as to legal representative should be decided by the lower court, and on pending appeal, the appellate court may direct the lower court to decide the issue of legal representative. This is most important. Section 6. If suppose everything was over and case is posted for judgment, then conclusion of the hearing and the pronouncing of the judgment, but judgment may in such case be pronounced notwithstanding the death, as if death had been pronounced before the death took place. So this Order 22 Rule 6 plays vital aspect. Sued by abated marriage of a female party. A female party is the defendant. She alone is liable, and likewise that deals with it. It seems to be not at present is valid. Then insolvency. if suppose the plaintiff or defendant became insolvent, what to do, what not to, Rule 8 says that. This abatement of the suit or dismissal of the suit due to death not bringing legal error is automatically you have to it is you cannot file fresh suit because it is bar under section 11 CPC res judicata. Assignment before final order in suit. If suppose the degree is the actionable claim is assigned, what to do is there. Then next most important is that it is the duty of counsel on record, either plaintiff or the defendant, to inform the court about the death of the party, and if any legal error particulars there, he has to give the particulars. Then all these order 22 rule provisions would apply for appeal also, that is covered rule 11. Then order 22 rule 12 clearly says this rule 3, 4 and 8 shall not apply to execution of degree or order. So this you should understand. I think you hope understand. Best wishes.